Our next panel is a panel in opposition. Eric Modell of the Collateral Loan Brokers Association of New York. Jordan Zabak Bank of the National Pawnbrokers Association. And Paul Solda, Esquire, of the New York Pawnbrokers Secondhand Dealers Association. Welcome.
Make yourselves comfortable, and I don't know who wants to start. Do you want to kick it off for us?
Sure.
Good. Go ahead. Let's just make sure that that microphone is on for you. Test it out.
Hello.
You're good. Thank you.
Thank you. Good afternoon. My name is Jordan Tabak Bank. I'm a proud pawnbroker in New York City and a director of the National Pawnbrokers Association. As the only nationwide trade association that represents the pawn industry and its independent pawnbroker members, the National Pawnbrokers Association appreciates the opportunity to submit a statement on Intro 1177, which we strongly oppose. The bill proposes that all transactional data associated with a pawn transaction, secondhand purchase from the public, or scrap transaction be shared with local law enforcement via an unencrypted electronic data upload. As a third-generation pawnbroker, I am keenly aware of many misconceptions that are associated with our industry, one of which is that pawn shops deal in stolen merchandise. This could not be farther from the truth. Pawn customers are hardworking New Yorkers in need of short-term safety net loans. In fact, the incidence of stolen items in pawn shops nationwide is less than 0.1%. The National Pawnbrokers Association opposes 1177 for numerous reasons, which include, but are not limited to, the following. 1. 1177 is based on the empirically unfounded and offensive notion that pawnbrokers are fences for stolen property and their customers are thieves. 2. 1177 violates consumers' federal statutory financial privacy rights and due process rights and will enable the NYPD to engage in impermissible profiling based on age, gender, ethnicity, zip code of residence, description of goods exchanged, and the amount of proceeds obtained. 3. 1177 offers no meaningful protection to consumers against the abuse of their confidential, personal, and financial information, or to pawnbrokers against the capture of their proprietary business records. 4. 1177 enriches third-party, for-profit software vendors at a considerable risk to consumers and cost to pawnbrokers, without providing more than a marginal benefit to law enforcement. By no means do we suggest that the NYPD will not receive the same level of cooperation it has historically enjoyed from pawnbrokers. On the contrary, pawnbrokers respect and rely upon law enforcement and have strong incentives to avoid stolen property. 1177 is based on a faulty premise and attempts to solve a problem that simply does not exist, while in the process stripping away the constitutionally protected rights of New York City's consumers and pawnbrokers. Pawn transactions are consumer financial products or services fully protected by Title V of the Federal Gramm-Leach-Bliley Financial Services Modernization Act of 1999. Both this federal statute and the associated regulations that implement it preempt local ordinance amendments such as 1177. Consumers using pawn transactions should not be denied the federal financial privacy protections that Gramm-Leach-Bliley affords to consumers who frequent banks, credit unions, security brokers for their credit needs. Would you want your retail purchases, auto leases, or ATM withdrawals shared with NYPD in the absence of some suspicion of wrongdoing? If not, please do not impose this same profiling risk on fellow New Yorkers. We respectfully request that this legislation be held for all of the reasons I just set forth and for all of the reasons articulated in our prepared statement. I thank you for the opportunity to appear before you, and I would be pleased to answer your questions. Thank you.
Good afternoon. My name is Eric Modell, and I'm president of... Good afternoon. My name is Eric Modell. I'm president of Modell Financial, the fourth generation president of a pawnbroker business, family-owned pawnbroker business that has operated in New York City for 120 years. I'm also the president of the Collateral Loan Brokers Association of New York and a director of the National Pawnbrokers Association of America. Today, we're talking about legislation number 1177, which would require the transmission of all transactional data, directly or indirectly, to law enforcement to be held indefinitely. This arises from the belief that stolen merchandise turns up in pawn shops. However, there's very little evidence to support this. As my colleague Jordan has pointed out, studies have shown that less than 0.1% of the merchandise that comes through a pawn shop is ultimately deemed to be stolen. The fact is, stolen merchandise is bad for business. Pawnbrokers lose the money and the merchandise and have no chance at recovery. Currently, Section 436 of the New York City Administrative Code authorizes law enforcement to inspect the books and records to ensure that they are being kept in accordance with the law. This section is not intended to authorize police to search the books and records without a warrant for known or suspected criminals conducting criminal activity. Precedent exists in People v. Ketta when the New York Court of Appeals found warrantless search of a business to determine if the business is trafficking in stolen merchandise violated Article 1, Section 10 of the New York Constitution. Pawn shops are a financial institution. Data mining of a financial institution is a violation of the civil rights of each and every customer of that institution. Would passage of a law requiring other financial institutions such as Bank of America, Banco Popular, or Morgan Stanley even be entertained? The tremendous amount of data mined, if this bill were to be enacted, would result in profiling, and customers would be treated as criminals simply for conducting business in a pawn shop or a second-hand shop. This amounts to nothing more than electronic stop and frisk, which is unconstitutional in New York. I refer you to my written testimony for greater detail on the issues that this bill raises, and I urge the council and its attorneys to examine the proposed legislation while considering the merit of our arguments. I welcome your questions, and I appreciate the opportunity to speak before you.
Good afternoon. My name is Paul Solda. My law firm represents the interests of 4 of the largest pawnbrokers in the city of New York, as well as the New York Pawnbrokers and Secondhand Dealers Association. We, of course, take the position that any proposed modification to this law would be unconstitutional per se. Let me take a step back and discuss the statutes and the relevant case law that really brings us here today. We start with the New York State General Business Law, Article 5, which, pursuant to Sections 43 and 45 therein, provide that the businesses must keep detailed records and make them available for reasonable inspections. And the New York City Administrative Code and the New York City Charter further develop these requirements to make them applicable to pawnbrokers within the city of New York. Several decades back, many business operations were deemed suspect and thereafter became closely regulated by government, not just pawnbrokers, scrap shops, garbage facilities, etc. It was in 1987 that the New York Supreme Court held that such warrantless administrative inspections of pervasively regulated industries, including pawnbrokers, was not violative of the Fourth Amendment. That case was New York v. Berger. With that, however, came a flood of law enforcement activity here in New York, which clearly surpassed the bounds of these inspection rights. As a consequence, it's been repeatedly argued that the NYPD and the city has consistently used the foregoing inspection statutes to justify investigations of criminal activity while circumventing traditional judiciary and legal requirements. For example, search warrants and subpoenas. In fact, you heard the NYPD quip earlier that how troublesome it is for subpoenas. That's exactly the heart of what the problem is here, in part. These abuses led to the 1992 decision of the highest court of the state of New York, People v. Ketta, which Mr. Modell spoke about. That decision ruled Section 436 of the New York City Charter unconstitutional. That section, by the way, goes hand in hand with the New York City Administrative Code and what you're all seeking to enlarge the law on. So keep that in mind. However, that 1992 decision has really been ignored because I guess it just hasn't been challenged at all, other than a few remote lawsuits. And the NYPD continues to run rampant with disguising criminal investigations under the guise of doing an administrative inspection. That court stated that the ruling was to curtail abuses and to specifically define inspection rights of law enforcement, as police are only permitted to undertake administrative inspections that are part of a defined, systematic regulatory scheme. These inspections must have been conducted on a regular basis as part of an ongoing program to enforce licensing and record-keeping requirements. Now, let's just think about that for a moment. Record-keeping requirements and licensing. It's not talking about tracking down a criminal. It's not talking about tracking down alleged thievery. The pawnbrokers and the entire industry are, as a closely regulated business, they're empowered with the responsibility to keep accurate records, and that's what law enforcement is supposed to do, is to go into the business to look at those records to make sure that they're being compliant. If there is, in fact, some criminal investigation going on, well, we have what we all started knowing as the Fourth Amendment to the United States Constitution and all the search warrant rules therefore, including the New York State Constitution and the rights of the use of subpoenas. The New York City Charter 436 was again held unconstitutional in a New York City criminal court just a few years ago. It was following the arrest of a prominent New York City pawnbroker who's here today. He simply asked for a warrant before allowing the police to search his business safe and its collateral jewelry. That particular Queens criminal court not only dismissed his criminal arrest and charges entirely, but it also took the prominent step of again echoing the Court of Appeals that Section 436 is in fact unconstitutional. That case, by the way, is cited in my memo. And again, 436 lies at the heart of the New York City Administrative Code. We still have all these abuses today. The proposed modifications here simply don't seek to follow the spirit of the courts on the defined law enforcement practice and constitutionality, or lack thereof. No, rather, it takes a nosedive into an unconstitutional realm where there is no escape. This is something that our democracy should not so easily permit, and really this council should not allow this bill to get presented. Real-time record keeping of the detail of a pawnbroker's loan transactions enables the NYPD, and wherever else the information may wind up, and I'll get to that in a moment, it enables them to scour all the transactional information within the comfort of their precincts and other situated locations. Of course, the use over the last decade of such web-based reporting entitled Leads Online has brought this to the forefront. We've been talking about Leads Online. We've learned through credible sources over the last 10 years that law enforcement developed their own software program which permits them to selectively search the databases of all pawnbroker second-hand dealer customers to run against recidivists and known parolees. Now, I'm a little insulted that the NYPD, all of them, left and can't face my questions, because the reality is they have a software program which they already developed, which enables them to take the Leads Online information and take the names and run them against recidivists or known parolees to make it easier for them to identify who, in fact, may have just been in a pawn shop or a second-hand dealer and may have, in fact, pawned or sold stolen merchandise. Now, isn't that racial profiling? I strongly suggest it is. You know, Justice Sandra Day O'Connor, our first lady female justice of the United States Supreme Court back in the early 1980s, observed in a case involving administrative searches that they're the 20th century equivalent of colonial writs of assistance. Those were writs and general warrants authorizing English officials to search any and all residential and commercial premises without particularized suspicion to enforce various trade regulations and restrictions. Such writs were an important component of colonial resentment against the Crown, and it in fact ignited the flame that led to American independence. I get goosebumps when I read that and think about that, because the fact is that aren't we here just taking another step about junking the Fourth Amendment? Isn't that really what's going on here? Because it is. Because the obligation of law enforcement, the right of law enforcement to do administrative inspections at the business premises is constitutional so long as it's part of a regulatory systematic scheme. It's done once every 30 days, once every 15 days, or I think as the captain quipped, once every 10 days, and they keep records of it, and they keep it even-handed over all the pawnbrokers and second-hand dealers, but that's not really what happens. What happens is they run in every day if they have to, and they're chasing the lead of a crime. And they're using the inspection laws to mask what their illegitimate activities really are. While these areas of regulated businesses, again, there's a substantial government interest in justifying inspections, they have to be for the purpose of the regulation of the business and not for the purpose of discovering evidence of criminality. How will this new law be part of a defined systematic regulatory scheme to inspect records? The new proposed law, in fact, turns further away and provides a stepping stone to socialistic governance. More importantly, they further relax the standards of the police that must abide by the general laws of our Constitution, both state and federal, for undertaking criminal investigations. And again, I find it shocking that the NYPD and the city has couched the discussion of this law and tried to mask it under the curtailing of the sale of stolen Apple products. Because while I'm just a lawyer for these businessmen, I do understand that about 99% of the collateral that they take in exchange for a loan is jewelry, is gold. So what you're really putting on them is asking them, or requiring them, I should say, to send all of their information, which they are in fact protected by the federal government because they're a non-depository financial institution, and they have an obligation to protect the privacy of their customers. You're asking them to send the information to the precincts. And from there, I'm sure the officers that don't want to work too late can then send it to their home, and they can sit with a donut and coffee and look at the information at their home computer. The fact of the matter is that that's illegal. That's unconstitutional. Again, I suppose if there's a way to carve out the sale of Apple products and other electronic products, I guess that may be something for all of you to consider. But in terms of the gold and the jewelry that the second-hand dealer and the pawnbroker do business in, that should not be a part of this equation. Thank you.
Thank you very much, gentlemen. I appreciate it. You've given us a variety of things to think about, although I do want to probe a little further on a couple of things that you have said, if you don't mind. First is the new requirements here of 1177, because as far as I can tell, if the police department of the City of New York wants to go into a pawn shop today and look through that logbook, they don't need a warrant to do that. Is that correct?
That's correct.
And they are not limited to looking for information about Apple products or any one product over another product. Is that right?
That's correct.
Okay. And this law doesn't add any new categories of reporting. Other than adding a photograph, it is the same stuff that you would otherwise be keeping in the logbook. Is that right?
Other than to say that it has to be kept...
Use the mic.
Other than to say it has to be kept electronically, that's correct. The
right,
photograph
okay.
is a new addition.
Okay. So, so what I'm struggling with is if there was a due process issue present here, it seems like it would have been present before as much as it would be present now. Am I missing something?
Yeah, I believe so. Right now, they can come in for an administrative search to look through your books and records and make sure your books and records are actually intact and that you're keeping books and records, which all pawnbrokers do. This would essentially allow for a search for stolen property without probable cause without a subpoena, a grand jury subpoena, without a warrant. It is no longer an administrative search. It's a search for stolen property.
And do you think that what the police department is doing now constitutes an administrative search?
Absolutely not.
Yes and no. Okay, so
what they're
you can start
supposed
with
to be
yes, and then you can
what
finish it
they're
up.
supposed to be doing is an administrative search.
But in reality, most of the times they're not.
I would say that the difference today with this bill is that this gives them unfettered access to all the information. If they have a particular crime and they are looking for a particular item, they come into one of our pawn shops, they are looking for something specific because they have a reason to be there. To have unfettered access to all of the information, which includes name, address, age, race, amount financed, none of which is pertinent to the property at hand, they can use that information for whatever they see fit, not only to find stolen property, but also to target suspected criminals.
They have access to all that information now, though, if they were to show up to your business, correct?
They do.
I mean,
but
just for clarity, the answer is yes to that?
right, but under the guise of an administrative inspection, they are to just be ensuring that the business is properly keeping records. Now,
You regard the police department's role in inspecting the books of pawn shops to be just about making sure that records are kept?
it's regular.
Only. There's no basis for the police department to interpret, analyze, make conclusions based on any of the information that exists in the logbooks. It's just about the maintenance of the logbooks from your perspective?
Well, I can suggest this, that if a police officer is doing an administrative inspection, whether it's justified or not, whether the pawnbroker believes he's really looking to trace the lead of a crime, if he sees a particular name in the book for a transaction that was undertaken the day before with a particular piece of article that was reported by a crime victim as being stolen, then what he is to do at that point is to ask the pawnbroker to put a hold on that collateral and then go to a court, to a neutral magistrate, to get a warrant or a subpoena. That's how it's done in this country. It's as simple as that. And I want to just return to one point that you made earlier, Mr. Garodnik, or you asked, I think, well, what has changed over the last decade or so, you right? Well, a lot has. It's just that everybody's ignored it. The People versus Keda decision in 1992 ruled this all unconstitutional unless they followed specific guidelines. And those guidelines, in fact, were reproduced by Lieutenant Grasso, Lieutenant Commissioner of the NYPD, if I'm not mistaken, in 1998, which set forth the guidelines. I've seen them somewhere attached to your papers. But even right now, there's a federal court lawsuit in which I'm representing one of the larger pawnbrokers. Right now, that got written up in the New York Post that was referenced as a footnote in your very papers. I believe it is footnote 13. And the point of the fact is that the police have been bullying pawnbrokers without a law in place for the last 5-7 years, and forcing pawnbrokers that don't use leads online to either deal with their heavy-handedness or go on to leads online. And so many pawnbrokers, and maybe there are some sitting in this room, in fact I'm sure there are, that are using leads online right now against their will. Let me say one last thing. The pawnbroker is to be distinguished from the second-hand dealer. And yes, while there's been a huge explosion in the growth of second-hand dealers over the last few years, and yes, they may truly be more of a magnet for criminal enterprise, the pawnbroker is making a loan. He's providing a service to everyone who, in exchange, those customers are entitled to reasonable expectation of privacy of their transaction, and that's under federal law. How does the use of leads online and where that information goes to, how does that speak to that right?
Let's talk about the broader question about administrative inspections. It's 2013. The idea that you guys or anybody else is keeping a triplicate pad which the police department walks into and has to decipher handwritten notes I mean, this is antiquated. This is old news. This is not the way I would think you guys want to be operating, and it surely isn't the way that we want the police department to be operating. How do you do an administrative search in a modern era where all this stuff really, if it's not, today collected online, it will be collected online, and the logbooks that we're talking about, they're a relic, right? So the question is, how do you do an administrative search when it is all kept electronically, and where the police department previously had to physically step into your shop and now may have the ability to access it always or periodically?
I'll address that. The first thing to consider is that, yes, what the captain said before, handwritten triplicate forms are not ideal. There are questions of handwriting, and that's understandable. In the efforts of the police, they've come into my shops, and I know several of my members, and they have allowed us to produce for them computer-generated reports. Now, in my own experience, I have provided such reports with the elimination of certain customer information, such as the name, the address, and the amount financed, because it's not pertinent to their stolen records. Search. I have offered that to them, and it has been given back to me saying they need the complete records. Today, they would take this form and they would bring it back to they would take our computer-generated forms and they would bring them back to the police department, and they would go through them and do with it whatever they did. It is my understanding that it was reverse engineered into a database, as Mr. Solda has said, and customers of our institutions were targeted for simply doing business here with us. They were identified and located. I can tell you from my own experience using Leads Online that one of the problems that we had was that there was too much information available. A police officer, case in point, and I'll tell you that I did subscribe to Leads Online for a few years, and I had several customer issues. One of them, the final one that happened, which is documented in my written testimony, is that a police officer went to one of my customers' homes at about 2 in the morning, knocked on the door, and aggressively was asking questions about the receipt for the item that she had pawned, and where she got the money to buy it. A thorough inspection of records, if the police had a reason to be looking at this particular customer, they would have seen that this customer has been a customer of mine for over 5 years, and the particular item in question had been in and out of my pawn shop for those 5 years. But they didn't look for that. They just saw that the woman had pledged a gold chain weighing approximately a certain number of pennyweights, and they had a report for a stolen chain weighing something close to the same amount. So I had that customer on the phone yelling at me for a very long time, and I've since lost that customer, but it's not the only time that we've had situations like that arise. In fact, in my duties as president of Clanny, I've been told that there's a pawn shop in the Bronx that does participate with Leads Online, and it has gotten, word has sort of spread in the community that that should an ex-convict do business in this particular pawn shop, they're regularly picked up immediately after transacting business, just to see what they did and where they got it from. The fact that they are conducting business in a pawn shop does not make them a criminal.
Okay, so you're raising broader issues than are present with this specific bill. You're raising questions about the police department's use of information secured through existing laws and regulations, and using that in opposition to transforming a relic of a system into a more modernized system. I hear your points about the process, although it does seem to me that if the police department, in the example that you gave with the woman who had brought that product in and out of your pawn shop over 5 years. With an electronic record, they probably could have seen that much easier as opposed to having to go through maybe
Excuse me,
five.
it was an electronic record.
Okay, and they weren't able to sort that out.
They did, for whatever reason, that incident happened in 2010, and I had subscribed to Leads Online since 2004. So the records were available on that particular woman. However, they were looking at at whatever had happened in that most recent report, and it wasn't a thorough investigation of the quote-unquote suspect or her.
Okay, so you're raising specific issues about police department activity as opposed to the benefit of making these records electronic. If I'm understanding you, I recognize that maybe having more electronic records make you even more worried about the police department, if I understand your testimony, but it does not answer the question as to why we should not be making these records electronic and more easily accessible for administrative review.
It seems to me that this is an efficiency argument, and with Gramm-Leach-Bliley, which we are covered under, there is not a balancing test for privacy. They don't say, due to the fact that this is more efficient, you'll forego the privacy concerns. And the National Pawnbrokers Association submitted a questionnaire to Leads Online and other third-party for-profit data reporting services requesting certain things. Where's the property stored? Where's the personal information stored? Do you own that data? And will you indemnify us if there's a breach of that data? Data is compromised. Data from the national government's been compromised from Fortune 500 companies. And when there's a leak, Leads Online has refused to answer the question of whether or not they would indemnify us. And just because this is arguably a more efficient approach does not mean it's a constitutional approach.
Just to follow up on Jordan's point, I asked the same questions of the NYPD about 3 years ago, and I'm still waiting for an answer. They assured me that those answers were coming.
No, I have nothing further to
Okay. Well, gentlemen, thank you very much for your testimony. It was very helpful, and we appreciate hearing from you and your presence here.